Good afternoon, everybody. Welcome to the kickoff of Ohio Life Sciences Two Big Things webinar series. I'm Tom Zych. I am a partner at Thompson Hine and co-chair of the firm's privacy and cybersecurity practice. Most importantly, Thompson Hine is very proud to be a member of Ohio Life Sciences and to have supported and continue to support the vital work that it does. We are pleased, on top of all of that, to be invited to present to you this series of webinars on cutting edge and front burner topics that'll be affecting your business and its success and the challenges it will face. We call this Two Big Things because we'd like in each of these programs to present two topics within the half-hour time limit we've set to raise and to discuss areas of compliance and legal opportunities and legal risks that you may face, all with an intent to make it useful to help you in operating your business and navigating the challenges you're going to be facing. We hope we provide some insights and suggestions on how you can manage risks and seize opportunities. And we'll do this over, as I said, a series of the 4 webinars that we'll be presenting. A few quick notes. This is being recorded, so it'll be available on demand, and we'll talk about that later, how we make that available. If you have questions, we hope this is fast-paced, but there is a chat feature, and you'll be able to enter your comments in the chat, and then we'll be providing afterwards contact information for our speakers where you can follow up if you've got questions and would like to hear more about these topics or ask questions or even make your own suggestions. Today, I'm quite pleased to be joined by 2 of my colleagues at Thompson Hine, Julie Honor and Debbie Brenneman. They are, if you don't know them already, recognized leading thought leaders in their fields and have very informative and interesting information to present to you today. So without further ado, I'll be passing the microphone to Julie, who will then do the same thing to Debbie. Again, if you've got questions, you can post them in the chat. I'll be watching that, and we'll try to pose them at the end of each presentation. So we're all on the clock, and Julie, it's your turn.
Thanks so much, Tom. Hi, everybody. I'm Julie Honor. I'm very excited to be here, and I'm going to talk about AI and predominantly generative AI. And we'll talk through what it is. I'll give a few examples of how you might consider using it or be actually using it in your business. We'll talk through some risks relating to AI and generative AI, and then close with some action items and an update on what we expect to see coming down the pipeline this year in terms of regulation and guidelines. So AI, we've been using it for years, and most of you probably are already utilizing AI. Think of like spell check in Microsoft Word, right? AI is a technology that can make predictions, recommendations, decisions, given a set of human-defined objectives. Generative AI is the newer form of AI technology that is AI powered by algorithms that are trained on data sets that can generate new content, like images, videos, audio, text, any other type of digital content in response to a variety of inputs. So I think most people are familiar with ChatGPT, which is an example of generative AI, but that's not the only one. There's a lot of other tools out there. There's Midjourney for image development. There's meeting assistants like Fireflies and more. And a lot of companies are starting to develop their own generative AI programs for internal use. And so as we talk through the rest of my 15 minutes here, 2 key terms to keep in mind are inputs and outputs. Inputs is the content or the text, image, video, sound, whatever you are putting into the tool as a prompt. And sometimes you're manually submitting it as a user, or it's automatically getting submitted depending on the program. An output is what you get from the tool, and however, in response to the inputs that you put in there. And outputs can be in a variety of different formats, like text, image, videos, sound, code, etc. So some uses that you might be seeing in the life sciences industry, just at a very high level and random examples. So one is document generation for clinical studies. You can train generative AI technology on your preferred formats for clinical trial protocols, clinical report forms, other contracts, and generate really great starting points to expedite and simplify creating these documents. If you have a ton of clinical trial notes or patient experience data, Generative AI can be used and trained to read, interpret the meaning, tag critical portions of the research or the document, and even create summaries or synthesize notes and reports. We have a function like this that we utilize in our document review generative AI tool, which is really cool to see how it works. Generative AI can also be used in chatbot features to engage with patients or folks participating in various clinical trials. As you've probably seen how it works with a lot of your like everyday vendors you interact with online when you're working with chatbots. So many different examples can come into play. And I just want to end on a very generic example that is not specific to the life sciences industry, but works for any company. And Debbie will probably get a little stressed out with this example because she's our employment lawyer on the phone. But imagine a hiring manager interviewing 2 candidates for a position, loads the job posting into the public version of ChatGPT, takes the 2 resumes they've gotten for these candidates, uploads them both into ChatGPT and tells the ChatGPT, what should I ask these candidates and who is a better fit for the role based on what you're seeing in here? Some really big red flags in that example, which we'll talk about in a moment, but you can imagine that if you don't have restrictions in place on or guidelines in place on the use of generative AI, people are very creative in figuring out how to use technology to help them every day. So let's talk through the different risks that exist in generative AI so that you can start getting your mind around how to really approach this technology in a way that can help your business, but also keep you from taking on unnecessary risks. And the first risk we want to talk about is bias and fairness. Behind every AI model are human decision makers who chose which training data to use. They designed the structure of the underlying technology. And inevitably, humans have biases built into them. As much as we want to think that we're unbiased, we all have implicit and unconscious biases, and that goes for the AI technology development world as well. And so biases or discrimination that's included in these models can then further perpetuate those biases and create biased or unfair outputs. I think a lot of examples we saw early on, if you ask some of these generative AI tools for image creation to create an image of a doctor, it almost always was a white male. Those are biases showing up in this technology, especially in the life sciences field. It's really critical to understand how generative AI models that you use or build incorporate equity principles into the technology and then monitor and mitigate risks for discrimination or bias in those outputs by having human layers of review and other kind of guidelines and guideposts in place with your entity. And so in the above example that we just talked about for the employee, there's a huge risk of discrimination or bias that could occur here by having an algorithm make an employment decision. It's also illegal in some jurisdictions to use AI to make employment-related decisions, such as in New York. So we want to be really mindful with how the regulations are coming into play, as well as the general principles of bias and fairness, and making sure we're in line with anti-discrimination laws. In terms of another risk is accuracy. I'm sure a lot of you saw the Pope in a puffy jacket, or you've seen some of the examples where generative AI just completely hallucinates and makes something up completely. Generative AI is one of the best liars out there, and the tools make mistakes, they contain errors. Sometimes they literally just make up content based what's on in their model, and they think it's what the user wants to see. And so we need to be really mindful of accuracy concerns within generative AI as you're utilizing outputs. Privacy and confidentiality is another big risk to keep in mind. At its core, generative AI is looking for intersections of data to increase the likelihood that the output you're getting is going to be what you want. And they need a lot of data to do this. And so you have to be really thoughtful of what you're putting into there, because a lot of these tools use both inputs and outputs to further train their algorithms. And so any data that you're putting into these public-facing tools could potentially show up in an output for another person. And so if you're including confidential information or PHI or PII, it's very, I mean, that is a huge risk of breaching your contracts and violating various laws relating to the protection of information. And going back to that employment example, again, highly unlikely that that company would have had consent for the applicant to make their resumes public. or disclose their personal information, like their address and contact information. And if that person put it into the public forum of ChatGPT, and then somebody later asked ChatGPT to create a resume for them, that is going to be something that the algorithm recognizes as a relevant output, and it could show up for a random third-party user down the road. And now you've breached your confidentiality obligations to these candidates. Cybersecurity is another example or another risk to keep in mind. These AI tools can increase the risk of data exposure and cyber incidents in a lot of different ways. And I'll give you a couple ways in which this happens. One is bad actors can use generative AI to impersonate an individual by creating a very convincing sounding phishing email, or at one of my clients their CFO got a WhatsApp video call from their CEO. And that's a normal way that they communicate because it's a global company. It was the exact voice, the exact image, mannerisms spot on. And the CEO asked the CFO to make a transfer of funds that wasn't out of the ordinary, but the only thing that was out of the ordinary was the CFO was on parental leave and was surprised the CEO reached out. So she reached out to the CEO and said, why did you ask this? I'm a little confused. And he hadn't reached out to the CFO. It was a deep fake where they had found all the public versions of the CEO and used that to create a very realistic video call of the CEO. So these tools can be really, really powerful in the wrong hands. The other thing, these tools are helpful in creating content that people don't necessarily have the full skill set in developing technology. So people building generative AI tools or just building new technology might be utilizing a generative AI tool to create the underlying code, but they don't have the knowledge and the skill set to make sure that it's set up with the right security parameters or built in a way that is as secure as it would have been built by a team of very skilled engineers. And so a lot of tools can have a risk of having a higher level of security breaches because they haven't been built in the right way by using tools to create it. So a lot that can happen in the cybersecurity side of things. Two more risks I want to just highlight briefly, not to discount their importance because they're hugely important. Intellectual property. Generative AI has risks both on the inputs and output sides relating to intellectual property. On the input side, you can really destroy intellectual property protections of trade secrets or patent pending discoveries the moment you start loading it into into one of these generative AI tools. So you have to be really cautious and have a lot of strict parameters of what can go into the tool as an input so you don't ruin your protections. On the output side, it's a really interesting, there's two different factors of concerns. One is a lot of these generative AI tools were trained on data that didn't necessarily have the rights to use those data points in the way that they're being used. And you can't always trace back where the underlying source is. And so while these tools often give you license, right, saying you have full license to do whatever you want with the content, they might not actually have the license to give you the license rights to give you, even though they're granting them. So you have to be cautious of whether or not that output is potentially infringing on somebody else's intellectual property. The other problem is the law hasn't caught up with technology yet, and most of the intellectual property protection laws, especially in copyright and patent laws, require human creation. And whether or not generative AI created outputs are considered human creations is going through the court system right now. And so if you're creating something really important to you or your company through the use of generative AI, there's a risk that you might not be able to claim those protections that you're hoping to claim because of the involvement of a computer helping to create that for you. So it's an area that is evolving, but something to just be very aware of. And the last risk I want to walk through is just really understanding the legal and regulatory compliance aspects to this. There's so many laws and regulations that govern how health-related data and customer data can be processed and used. And we're actually, I'll talk a little bit more about this in a moment, the US government's actively in the process of establishing new regulatory guidelines around the development and use of AI in the healthcare industry. And non-compliance with these laws could expose significant financial risk and reputational damage. So it's just another factor to be wary of as you start to explore this new technology. So as we start to round out our discussion, I want to leave you with some actionable steps. It's really exciting and full of opportunities within this new technology to accelerate your growth in the company and improve efficiencies across the company. And you can really mitigate against these risks in a few different ways. And I think the easiest, not necessarily, but one of the best ways to do it is to have a strong policy that is accompanied with strong training. Work with legal counsel to help you really understand what are the specific risks, nuanced and bespoke to your company and the manner in which you want to use, or you think you might be using generative AI, and what type of process controls can we put in place to really make sure that you're minimizing each of those different risks that we walked through. And then making sure that you're training your company. Putting a policy in place is great, but if you just put out a piece of paper and do nothing, you really can't expect your employees to really follow through with that. And so really having that a collaborative effort with legal counsel to have strong training on a regular basis for your employees as well, if you're going to be utilizing the generative AI technology. And let's see. The last thing is just keep an eye on the new regulatory frameworks that are coming out. There's the EU AI Act that is going through final stages. We anticipate that's going to become final in April of this year. And then the US government is really working hard to meet the deadlines that were set in that October 30th executive order. They have about a year to get all of the different regulations in place. And so just keep an eye on those two things. Feel free to reach out if you have questions, if you want to discuss anything. I know I kind of went fast through this, but I'm going to turn it over to Debbie now.
Thanks, Julie. Thank you for giving me a panic attack. I'm going to have to run out and send a blast email to all my clients to say, stop with the AI in the hiring process. But it's a very, very good point. The one big thing I want to talk to you guys about today is that it's time to get your trade secret house in order, because the non-compete world is getting increasingly unpredictable. As you probably are aware, there are a growing number of states that either prohibit or nearly prohibit non-compete agreements. Certainly, we all know that I don't think you can utter the term non-compete in the state of California without risking jail time. But there have been a growing number of states in the last couple of years that have added on to that list. North Dakota, Minnesota, Oklahoma, all but bans non-competes. The District of Columbia has a very interesting non-compete statute that not only prohibits the use of non-competes post-employment, but even says that you as an employer cannot prohibit your employees from competing against you while they work for you. So that one is always one of my favorites to talk about. New York was set to join the fray of states banning non-competes. The legislature passed a bill that would have banned non-competes. It sat around on the governor's desk for 6 or 8 months. And finally, a couple of weeks ago, she had initially been expected to sign it. She did veto it, but the inside talk is that we'll see a new bill that probably has some salary caps or thresholds, allowing non-competes above a certain salary threshold. And that certainly is more in line with what we've seen a number of states do. We've got, for instance, Oregon and Nevada. Nevada prohibits non-competes for hourly workers. Oregon has a salary threshold of $100,533. Not sure where we came to that exact number, but you know, these statutes are crazy, and a 12 months maximum. In Illinois, that statute has a built-in escalation clause. So there's a threshold for the use of non-competes, a separate threshold for the use of non-solicitation agreements, and those change periodically over the next few years. Maryland has a similar statutory cap. And Virginia has this weird calculation that you have to calculate the average weekly earnings for low-wage employees, and non-competes can't be used in that threshold. I will say, by the way, that I do blame Jimmy John's for the rise of all of this non-compete statutory framework, because if you remember a few years ago, there was the famous case arising out of New York where delivery drivers were signed up to non-compete agreements, and it certainly certainly, number one, should never have been done. I would never have allowed a client to do something like that. But certainly caused an uproar and caused a lot of folks to start looking at the use of non-compete agreements. We also have some things happening on the federal level impacting non-competes. In May of 2023, the General Counsel of the NLRB announced her view that the proffer, maintenance, and enforcement of non-compete provisions violates Section A1 of the National Labor Relations Act, and sort of issued a call to arms to the local offices to look for non-competes and begin enforcement actions as necessary. There's actually been an action started in Ohio in the last couple of months. And you probably all are in tune with the fact that the FTC is eyeing a ban on non-competes. So in January of last year, they announced this proposed rule, which would be a complete ban on employee non-competes. Anybody who's a worker, independent contractors, employees, no matter what level they are, no matter what salary they have, the rule furthermore would be retroactive and would require employers to notify those employees who have non-competes that they're null and void, and it would override any existing state laws. We were initially expecting a vote. There was a public comment period. That public comment period got extended because there was just an overwhelming amount of comments, both in favor of the rule and against it. And so that comment period was extended through April of last year. We were expecting a vote, and then news came out that the FTC was going to give it this further consideration. We're now expecting a vote on the rule in April of this year, so in a couple of months. So a couple of things. We don't know what will happen. They could come out and say, yes, we're going to go ahead with the rule as is. There were a couple of routes that the FTC was looking at. One is maybe going along the state law trend of setting some threshold for non-competes. You can't use them with employees who earn less than X amount. It could be a position-based threshold that they could be used for senior managers or executives or officers. Don't know how that would be defined. Don't know if that would be well defined. There probably would be some challenge to what that means. And certainly we expect any rule that the FTC does issue to be subject to immediate legal challenge. There are a number of organizations who have already announced that they will fight this in courts as not being an authorized rulemaking pursuant to law. So we expect that there could be a rule, there could be an immediate challenge, there could be an immediate injunction, and then we'll see how this plays out in the courts. We do know that under the FTC's proposed rule, some things would still be permissible. Confidentiality agreements would still be permissible, and non-solicitation agreements would still be permissible, as long as they are not so broad as to function as non-competes. So for instance, if a salesperson had a non-solicitation that said he or she could not solicit any customers of the company for a period of time after employment, that probably would be a de facto non-compete because it would not be tailored to those customers that individual either had contact with or had some confidential information about shared with them during the course of employment. So we will see. So with all of that, again, it is really time to focus on making sure that you are protecting your trade secrets and reserve that opportunity to use enforcement actions to protect those, or even potentially to enjoin former employees from going to competitors if you can show that they have trade secret information and have misappropriated it or would inevitably utilize it, at least in those states that recognize the inevitable disclosure doctrine. And in fact, in defending its proposed rule, the FTC pointed to the Federal Defend Trade Secrets Act as another avenue that employers can use to protect their information and their competitive status. I certainly take issue with this because eliminating non-competes, it's great to say, we're not going to use non-competes in certain contexts for low-level employees. But even if we're allowed non-solicitation agreements across the board, that's not going to provide much protection when you're talking about top C-suite type of individuals, top managers, creative people, scientific people in your space, because those people would not be interfacing with customers per se, and a non-solicit would not do much. So again, we come back to the trade secrets world and making sure you're protecting that. So in looking at trade secrets world, first of all, it's important to know that trade secrets are not protectable unless you take reasonable steps to protect them. And that means you need to be looking now at how you define and protect your trade secrets, because once somebody leaves with your trade secrets, it's too late to change that fact. So you should be making sure that you are identifying trade secret information for employees, limiting access to your trade secret information to those who have a need to know. Do things like using your passwords, secure logins. Now in the remote world, maybe do double-step authentication, use firewalls, consider encryption. Certainly consider the changed working environment, the post-COVID environment, because we've seen cases where a company gets on Zoom and shares information with potential franchisees, and because they did not follow either Zoom protocol or even their own protocol for those web-based meetings, a court held that they had no right to protect their trade secret information because they shared it. It was no longer secret, so they weren't taking those reasonable steps. So we need to make sure, employers really need to make sure that they are having their employees learn and use security measures on remote communications platforms. I know we've got participants today who are in public places, so that needs to be part of the trade secret strategy too, with regard to your employees. Now that hybrid work or remote work is the new norm, you need to make sure you have take into account other considerations. There are increased hacking risks. How do you deal with the remote handling of trade secret documents and information? If someone's sitting in a Starbucks and pulling up trade secret information, there's a risk other people could see it. How are they handling documents? If they're working from a home office, are there others in the household who might be overhearing their conversations? Do your trade secret papers get left laying around? Are they cross-mingling your information on their personal devices? How about other types of inadvertent disclosures to those who may be, coming in and out? So you need to make sure that these additional considerations are put into place. Home security measures are essential. Make sure there's a policy that says, if you work from home, this is what we expect you to be complying with. This is how you manage hard copies of documents. This is what you're allowed to download or not download. You may or may not use electronic storage devices under these terms. Here's how you must set up a private room or a private environment for you to be able to deal with this information. Certainly up the ante on who needs to know the information. Go back through your policies and determine who may be accessing all your types of information, and should that be further limited. Make sure you are having personal device use policies, and if you're going to allow cross-mingling or the use of personal devices for company information, then make sure that you have some thresholds for that as well. Require updates, require baseline security, consider using remote wiping technology. And consider using monitoring policies. By that, I mean, there are a few different types of monitoring that you can do to make sure that you are protecting your assets. So you could do routine monitoring. Every so often, you have your IT department look at what documents people are looking at, and do it on a random basis, sort of like a random drug screen. There's suspicious use monitoring, and there are vendors who can supply this kinds of software for you. But suspicious use would be if someone typically accesses 10 or 15 documents in a day, and all of a sudden they're accessing 150 documents. There's probably something going on there. And I see it all the time. I have a case right now that the night before this individual tendered their resignation, they went through and put on a thumb drive about 250 different pricing lists, RFPs, sets of documents. And this was caught because they have a shared backup But that type of suspicious use monitoring is key, or also key data monitoring. Define what are your most sensitive documents and have IT get a notice every time those documents are accessed, so you can determine if that access was appropriate. And just winding up my part of the presentation, make sure you have policies that address the departure of key employees. So for those employees who really, if they went to competitor, could just stab a stake in the heart of your business, make sure you have plans in place for how you monitor and deal with them. Consider whether you're notifying their new employer of the obligations, ask about their post-employment plans. Certainly retain their hard drive at least, or consider having a vendor conduct an evaluation of it. Don't let your IT department do that. It has to be something that's properly preserved. So consider what you do when somebody who's key to your organization departs. And I will close with just a little pitch that we do here. Our group does trade secret audits, which can help ensure that you have those proper policies in place, can develop protocols for key employees, certainly can also take a look at your non-compete and non-solicitation agreements. As you have heard from this presentation, one standard agreement across the country with all your employees is not acceptable. It's not a one and done. You need to make sure they're updated. They are state specific, they are position specific, they are enhanced for the greatest protection of you. And we can handle that in an audit. So happy to talk to any of you if you may be interested in that. And with that, Tom, I'll turn it back to you.
Thank you, Debbie. And Julie and Debbie, thank both of you. We don't have questions on the chat, but we will be sending out contact information. If you want to raise this, we're more than happy to talk with you, just as I said, part of our service to Ohio Life Sciences and its members. I want to thank John for helping us arrange that, Pat Nagorski from our firm for helping with all the logistics behind this. Stay tuned. There'll be additional information coming out on the other 3 planned webinars as part of this series. Next one will be March 6th. So same time, same channel, same methodology. And again, feel free to reach out to any of us, or you can reach us through John. And thank you for taking the time. And we look forward to seeing you all again, and enjoy the day. The weather should actually be pleasant for those of you here in Cleveland. So goodbye, and have a wonderful day.